We are live. Hello, everybody. My name is Howard Klein. During this webinar, my panelists and I will be discussing an uncomfortable topic, bankruptcy. While we are not encouraging anyone to file for bankruptcy protection, we believe that the economic hardships experienced by landlords and tenants alike during this coronavirus pandemic, at a very minimum, requires a review of your bankruptcy rights, obligations, and strategies now. This webinar is for landlords, tenants, property managers, and any other business that has any type of a relationship with commercial real property. From my perspective, that's almost everyone. My panelists and I are not providing legal advice in this webinar. Our intent is to educate and inform. With this said, we encourage you to contact us for legal assistance. As such, this may be considered attorney advertising. So if you're uncomfortable with that, hang up. Some questions that we will be discussing are: who should be considering bankruptcy options? And again, this question really doesn't go to the issue of whether or not you're planning on filing bankruptcy, whether or not you should be considering filing your own bankruptcy, but what if the people that you're doing business with might be in a position to file bankruptcy? Answering the question, why should you be educating yourself? And generally, top bankruptcy issues for landlords and tenants. First, a little housekeeping and discussion of the conduct of the webinar. I'm going to do old style radio. Okay, that's gone. Let me start out by introducing the panelists. Might as well start with me. I'm Howard Klein, also known as Howard F. Klein. I've been an attorney for over 40 years, handling general business matters. On a number of occasions, I've been in-house counsel and director of real estate, and my special emphasis is on commercial real estate, landlord-tenant matters, including lease negotiations, rent collections, and large evictions. Sarah Chenitz, if you don't tell anybody, she's my cousin. Sarah is a partner in the bankruptcy and restructuring department of the international law firm of Perkins. Now I'm going to mess this up. Is it Coie? Coie. Okay. Sarah represents clients in multiple jurisdictions and has served as a bankruptcy trustee. Her office is located in Los Angeles, California. Richard Gullibo. Did I pronounce that correctly, Richard?
Yes, you did.
But you can't see that I misspelled it on. You knew I was going there. Richard is a founding partner and the managing partner of the bankruptcy and restructuring law firm of Winthrop Gullibo Hollander, located in Orange County, California. I'm making these introductions of the panelists really short because I want to get to the topic. So we will be providing on the website and later on how to get a hold of each of us. And then we have Catherine Francis, last but not least. Catherine is a partner in the litigation group in the bankruptcy and insolvency group of the Canadian law firm of Minden Gross LLP, located in Toronto, Ontario, Canada. Did you like the way I added the Ontario?
Very nice.
Yeah, because on legal stuff, this makes a difference.
It does.
So let me remind you that each of the panelists have volunteered their time to promote their businesses and services, including myself. I encourage anyone viewing or participating in this webinar to contact each of the panelists directly if you are interested in our services. And now we are going to get further into the webinar. All right, thank you very much. So let's start out with Richard. You were going to talk briefly about, why we're talking now about bankruptcy. Isn't it a little premature?
It's never premature. And the reason why I say that is because the ultimate goal for my clients is always to avoid bankruptcy. We consider bankruptcy as generally being the nuclear option. It's when all other efforts to consensually resolve issues just they fail. So what we always want to do is we always want to take a look at, for example, Chapter 11 bankruptcy and see what the benefits are and weigh and balance those benefits with respect to any kind of consensual resolution we're trying to reach out of court. So, for example, some of the benefits for a bankruptcy would include that you get an automatic stay. So to the extent that there's going to be any kind of litigation that's been commenced or is being threatened, you file a Chapter 11, you're going to stop that. If you're in a Chapter 11, you're able to shed burdensome contracts and leases. You're also able to sell off valuable contracts and leases. And also, to the extent that you want to sell assets, you're able to do so free and clear of liens, claims, interests, things of that sort.
Well,
However,
let me interrupt you for a second. In the context of the coronavirus pandemic right now, I suppose that there were some landlords and tenants who are having financial problems before all of the shutdowns. But for those who were relatively healthy and have been severely stressed economically by the shutdown, I mean, why consider it now? I mean, it's you're not necessarily planning for the Chapter 11. Maybe their financial stress is only in the last 2 or 3 months. But the reason why I've included you and Sarah and Catherine is because I've been talking a lot about rent relief negotiations. How does all of this affect your rent relief negotiations and knowing about bankruptcy?
well, what you try to do is you try to consensually resolve the inability to pay rent now by taking a look at what would happen in the event that you can't consensually resolve issues. So, for example, right now, it's interesting, I have 2 separate tales with respect to the same client, but it's 2 different landlords that I've been negotiating with. On the one hand, we have a landlord who recognizes that my client was very profitable, was very successful, was paying rent like clockwork, and was more than willing to come up with a very, very short form amendment to a lease agreement where it right out of the gate said, we will defer rent for 6 months. No need to pay for 6 months. And then what you could do is you could amortize those payments over the remaining 36 months, and we're going to charge you a little bit of interest. That was an excellent proposal from a landlord who truly understood that this is a client that had a propensity for paying rent like clockwork. The flip side to that was we had another landlord we were negotiating with where it was a 4-page letter that they sent. The first page that they understood COVID-19 and that we're all in this together. And then they gave a 3-page checklist, single-spaced, of all the financial information and other confidential information that they wanted. Plus also, they wanted my client to waive any and all claims that my client may have against a landlord just as consideration for them to review a request to defer rent.
That's a little heavy-handed.
So, very much so. So the thing is that so we take a look at those 2 different scenarios and then reflect against those 2 different scenarios against what the bankruptcy code would allow for, or what kind of benefits we can get by filing for bankruptcy. But once again, we're always trying to just stay out of bankruptcy if we can, because of the fact that it's a very, very expensive process.
Sarah?
Yeah, I think you want to do the same thing that Richard just described on the other side, from the landlord side. Richard was talking about it as if the tenant is the prospective debtor. And if you're a landlord and you're concerned today that one or more of your tenants may file for bankruptcy, and that may be a while off, including because you can't evict them for not paying rent in most places in the country now, most big cities. based on local rent moratorium that are in place. But you want to stop if you're the landlord and think about, do you have an LC? When can you draw on it? How do the local changes impact that? How would bankruptcy impact it? Which most often it doesn't, but it doesn't affect your ability to draw an LC. Typically, you have to look at every LC individually because there are exceptions. And at the same time, bankruptcy may have the opposite result in a security deposit. Depending on how your security deposit is structured, you may not be able to apply your security deposit prior to bankruptcy, but if you acted the day before bankruptcy, you could have done so. And then again, too, there are issues on what's the impact if there is a bankruptcy, and timing issues. That sometimes getting paid 91 days before a bankruptcy puts you in a very different position than getting paid 89 days before bankruptcy. So there are strategies to think about well in advance of a bankruptcy from a landlord point of view as well.
And that's all part of these rent relief negotiations. Catherine, tell us from the Canadian perspective.
Well, really the same kinds of considerations apply in Canada as in the US. When tenants and landlords are looking at their leases, often they're tightly drafted so that there's no legal entitlement to get rent relief, and the only way to do it is through a negotiated resolution with the landlord. And of course, the incentive for the landlord is, what are my alternatives if I say no? If I say no and the tenant ends up taking some kind of insolvency protection, the landlord may get nothing and lose a tenant. And if the landlord has a shopping mall where all or most of the tenants are closed, they're not going to be able to easily replace that tenant. So it's important from my perspective for both landlords and tenant to know what the remedies are in insolvency and what they're going to be facing if they can't come to an agreement. And I believe that's one of the driving forces for landlords being reasonable with tenants. They're looking out for their own interests. They want to keep those tenants. They don't want them going into bankruptcy protection, having the rights stayed, and potentially going out of business. So
let me take a bit of a diversion. Sarah, you would lifts, the other stays. I think that was the rules of court have been changed in order to allow for that. Also, as part of those changes in the temporary changes to the rules of court was the issue of applying whether or not landlords can apply an existing security deposit, which in most instances in California you can. But the real question is, could the landlord then go back and ask the tenant to replenish that security deposit? And I don't know, as a practical matter, it may not make any difference if you can't file for an eviction. And again, we're talking about in commercial. What about letters of credit? Good
question.
Yeah, can landlords draw upon a letter of credit, and I don't know what the answer is, because I didn't see anything that said you can't draw upon a letter of credit.
Well, there are, even within California, there are different rules in effect in different cities. Santa Monica is a little different than Los Angeles, for example. And if people want to see the details, it's available on a nationwide survey is available on Perkins Coie's website. But from what I have seen, those I've looked at, and I've looked at select ones for particular clients based on where they are located, I haven't seen any ones that have addressed the letter of credit issue. It's something people may not have thought about. Letters of credit are pretty sacrosanct and very strong protection for landlords. But it is an interesting question. Not only, there's nothing that legally that I'm aware of that prevents a draw by any pronouncement. And I think that would raise a whole host of enforceability issues if they attempted to do so. But the replenishment issue, if they're drawn, is a question. And there's also going to be a question, and maybe litigation that we will see before long, on if a landlord draws an LC now. There could be tenants, there could be groups of tenants making arguments that it was not proper given what kind of moratoria are in place. But remember that those are on evictions. There are also things that say you can't evict because the rent hasn't been paid. I'm not aware of any that says the rent is waived. And there's going to be there's a lot of discussion in the property owner community, because obviously this impacts the ability of a property owner to pay its own debts. Usually most properties have substantial mortgage obligations or other financing obligations. So there's also a chain reaction on the cash flow that's coming in. And this could promote need for landlords to consider their own remedies, bankruptcy and otherwise, if this continues for a long time, particularly, as there's less traffic, there's not going to be new tenants in many instances. There's going to be a lot of issues on that side as well, I fear.
Let's talk a little bit about the CARES Act and the changes to the bankruptcy code as a result of the CARES Act. And then I want to make sure, Catherine, that you pipe in with any similar type relief that has been offered by Canada. Sarah, why don't you talk about the CARES Act and what the changes are?
It's interesting in that the CARES Act's impact on the bankruptcy code is to amend a section of the bankruptcy code that's only about in effect for 3 months. There's a new section of the bankruptcy code that was available starting about February, enacted not through the CARES Act, that made streamlined provisions for a small business to reorganize. So it takes away some of the burdens and therefore costs of Chapter 11. And it has limited, but you had to have very low debt to utilize that provision of the bankruptcy code. That's been raised through the CARE Act, that the debt limit is now $7.5 million in the aggregate, which for some businesses is a lot and for some is barely scratches the surface. But for small businesses, it can make bankruptcy more appealing. It reduces the cost. It reduces the time, some of the administrative burden. Bankruptcy courts are still functioning very well, albeit remotely these days. So it's an option available to landlords, tenants, others that comes specifically through the CARE Act.
Richard, aren't there some other changes other than just increasing the debt limit?
Oh, yeah, there are several. So first of all, there's an expedited timeline where you need to file a plan within the first 3 months of a bankruptcy. You don't need to file a disclosure statement. All you need to do is file a plan. And there's typically not going to be an unsecured creditors committee that gets appointed. There is a trustee that's appointed, but it's not a trustee that's put in place to run the business. It's a trustee that's put in place to assist the debtor in accomplishing its goals in this specialized Chapter 11 program, trying to get the debtor out of bankruptcy as quickly as possible. Also, United States trustee fees are waived under this subchapter 5, and those fees can start to mount and become pretty substantial. So in total, this new bankruptcy or portion of the bankruptcy code, which was, I believe, enacted February 19th, and it had a $2.7 million debt limitation when it was first enacted. Now with the CARES Act, it's tripled to, well, a little less than tripling to $7.5 million. It's in effect for about 1 year. So that's the interesting thing, is I'm wondering whether or not when the 1 year passes, whether or not Congress is going to revisit this and say, you know what, $7.5 million seems like that's a lot better number to give a lot of corporate debtors relief under a streamlined, much expensive process than your traditional Chapter 11. That's what I'm actually hoping for.
Me too.
Okay,
Yeah.
so
Catherine,
speaking up for Canada, I heard a reference to moratoriums on evictions, and So far, those moratoriums have only, except maybe in 1 or 2 jurisdictions in Canada, not Ontario, have only applied to residential tenants as opposed to commercial tenants. So we haven't gone quite that far in terms of moratoriums. And there are not changes to the bankruptcy and insolvency regime. On the other hand, our regime has always had a process for smaller commercial debtors as well as consumer debtors to make proposals under the Bankruptcy and Insolvency Act. So that is already a streamlined process. There's no need to change. We actually, and I'll probably get into this later, we have 2 totally different insolvency statutes. One of them sort of mimics or tries to mimic the Chapter 11 restructuring, and the other is the Bankruptcy and Insolvency Act, which allows both for bankruptcies and for bankruptcy proposals. And it's not a difficult or necessarily expensive process. So that's already in place. And as far as I know, no changes legislatively as a result of COVID.
Oh, okay. So I've got another poll question. Let's keep everybody active here. Let me switch. The poll question is, okay. Poll question: would you do business with someone who has filed bankruptcy within the last 10 years? Who would like to raise their hand first and pipe in as to what your reasoning, whether or not someone should be doing business and whether or not 10 years is the proper time period to think about versus something like 7 years, etc. Oh, my earpiece fell out. Go ahead.
I'll go. I mean,
okay.
I think you, like any other, should be next to a non-issue. In fact, doing business with a company soon after bankruptcy, they have debt's been discharged. They're starting from scratch. They may have new financing. They may have new equity. They may have gotten rid of a lot of burdensome contracts. So it can be a very good party to do business with a company that successfully emerges from bankruptcy. And it's if it has secured debt, you can expect that's being closely monitored by others as well. And most of us do all the time without thinking. Maybe it's a little bit airlines, retailers. I mean, a lot of the household name ones are further out than 10 years, but how many of us went to Macy's within months of Macy's emerging from bankruptcy, and here it is, a retailer with problems, and it's furloughed a lot of folks, and we're in unique times for retail. Airlines, the same thing. Most American airlines, United States airlines major airlines have actually gone through bankruptcy or are the product of having acquired assets out of a bankruptcy in the case of Delta.
My thoughts are, it depends why someone has been through bankruptcy. Is it a fundamental problem with the business? I'm going to guess. We don't know what's going to happen, but I think companies that go bankrupt because of the COVID situation directly related to it, which is unprecedented, I don't think people are going to hold that against them in the future if they manage to get back on their feet and restructure, as long as they have a good track record before that. That's just my opinion. Of course, who knows what's going to happen in the future, but if you have a good reason like this, and this couldn't be a better reason. I mean, I know we're going to see this as an excuse for every bankruptcy in the next probably 5 years or maybe longer, but a lot of times it's going to be valid. So,
Richard.
So for me, it's a maybe. And my focus is going to be more on the smaller businesses as opposed to a Macy's or an airlines. So for example, let's just say that if you have a small business that filed for bankruptcy, let's even say 5 years ago, I'd want to know what the precipitating factors were that led to the bankruptcy. And also would want to take a look at the court docket to see, well, what happened? Were there really bad things that were discovered during that bankruptcy? So for example, if you were dealing with an insider who may have skimmed a substantial amount of cash in a bankruptcy, or it was discovered in a bankruptcy, and then all of a sudden you may have an insider's look as to how someone is acting or will act when their back is against the wall with respect to financial obligations. So I like the fact that if you do have a bankruptcy, you can go ahead and take a look at a public court docket and then assess. It gives you more objective, credible information to assess when determining whether or not you want to do business with someone who's on the cusp of bankruptcy or in a bankruptcy.
I actually, Richard, I agree with you the most on this. My experience, I know that bankruptcy should be the nuclear option, but my experience has been collecting against tenants during recessions, and I found that most tenants are so reticent to even consider bankruptcy that they wait far too long. It has not been uncommon. And when they wait far too long, what happens is they start robbing from Peter to pay Paul. And that's when they start getting into problems and issues. It was not uncommon during recessions for me with those tenants who could use someone with a little bit of empathy. I would try to speak to them and say, look, what's the situation here? Maybe you should consider bankruptcy. I never reacted well to anybody who threatened bankruptcy, because when they threatened bankruptcy, then I would give them your name, Richard, and your phone number and say, call him right now, because I don't want you to waste my client's money going after you to try to collect this if ultimately you're going to file bankruptcy. I'd like to know what's going on. Don't wait around. At least find out what's going on. And of course, most of the time they don't take my advice because I'm the other side, but it really is good, solid advice, which is part of the reason why we're talking about this now. You don't wait too long. Know what you need to know right now. Don't learn 3 months from now.
Well, and to that point, I was going to say it's really important, I think, to always be proactive. So be proactive with respect to understanding your business, understanding how you could cut expenses, understanding when you cannot pay a creditor, and then be disclosure oriented with your creditors. What I always am advising clients is call that creditor that you owe money to, explain the situation. And even if you can't pay in full, at least try to come up with some sort of consensual resolution where perhaps it's even a partial payment, because of the fact that it still winds up being a situation where that creditor is top of mind for the debtor. And I think that creditors appreciate that. For example, if someone's owed $10,000 a month for rent, and you can't pay it, but you could pay $1,000, $2,000, whatever it happens to be. I think that that's a lot better than just stiff-arming a landlord and saying, yeah, we're not paying. And also, we're not returning phone calls, and we're not being disclosure-oriented, and we're not here to really work things out. That's just a recipe for disaster.
And
I just want to step in and say, just because you file under bankruptcy statutes in Canada, either under the Bankruptcy Insolvency Act or the Companies Creditors Arrangement Act, that doesn't mean that you necessarily become bankrupt, because the point of the statute, the main point, is to try to reorganize your debts, negotiate a resolution with creditors, get it approved by the court, and come out. And at the other end, if you come out successfully, you're not bankrupt, and you haven't been bankrupt. You've had a successful restructuring. So don't assume just because you're filing means you're going to end up bankrupt.
Or in U.S. parlance, having to liquidate, having
Yeah.
to shut down.
Right.
Yeah. Another reason, I think, to follow up on Richard's point as well on reasons to talk, the bankruptcy code has a lot. If you're a tenant having trouble, while you talk to your landlord, the bankruptcy code has a number of protections for landlords when it's tenants or debtors. Very interestingly and important for both sides to be aware of now, courts very recently have, bankruptcy courts, suspended the requirements of the bankruptcy code that require rents to get paid on a current basis, post-petition. Post-petition being post-bankruptcy, filing for petitions, how a bankruptcy case is started. So that while there's lots of protections for landlords on a go-forward basis under the bankruptcy code, though the law and whether you go forward from the first day of bankruptcy or the start of a rent period varies in different parts of the country. In the Modell's case, in the Pier 1 case, two large retailers, courts have held off the obligation for the tenants to pay rent despite what the bankruptcy code says in recent weeks. And I expect that's going to be precedent that followed. At some point, it may be that an appellate court says you can't do that, bankruptcy court, but for now, landlords are not getting paid.
Wow, that's big. Again, that's putting a hold on any kind of action in terms of getting paid or evicting a tenant. Let me step back a second, because Catherine talked about what the purpose of the restructuring is to go in, negotiate in a Chapter 11. I think that we're really talking about coming up with a plan, negotiating with the creditors, and then coming out of bankruptcy. My experience, however, is that in most cases, most companies don't come out of bankruptcy. Either Richard or Sarah, tell me what the percentage is that actually effectively come out of bankruptcy, unless it's changed over the last couple of years.
I don't know that I have a percentage that I could offer. However, what I can tell you is retailers that go through a Chapter 11, that there's a very, very high percentage that go back in for a second Chapter 11, what we call, bankruptcy lawyers will call it a Chapter 22. And by the way, there's no volume discount, by the way, in case anyone's wondering. So a case in point, True Religion just filed. And I think to Sarah's point, I believe that they've also requested that they not have to pay rent to their landlords. And I think that they have 87 locations and about $2 million. I believe it's $2 million a month or close to it in outstanding rent obligations that they're not going to need to pay for the first 2 months. So anyway, but that said, yeah. So once again, I don't have a percentage, but I do know that a lot of Chapter 11s or businesses that file for Chapter 11, they may confirm a plan and then they can't consummate the plan, meaning abide by the terms ultimately, or they file an 11 and then they can't confirm a plan and the case gets converted generally to a Chapter 7, sometimes dismissed on rare occasion, but typically converted, and then the company is liquidated in the bankruptcy.
Okay. Why don't, unless there are any other comments, let's talk about tenant bankruptcies. And Richard, we're going to start with you on this. Are there different types of bankruptcy filings? And maybe you could mention, what those differences are. This is in the context of a tenant bankruptcy. Okay.
So there are multiple, there are different chapters of the bankruptcy code. There's a Chapter 7, which is straight up liquidation that's available to individuals and to companies. There's a Chapter 9, which deals with municipalities. We don't need to get into that. There's Chapter 11, and I view Chapter 11 as, in effect, really having like 3 different subsections, so to speak. Your general Chapter 11 filing, your single asset real estate case, which would be a special election that you make when you're filing the petition. There's an expedited timeline and certain restrictions when indicating that the debtor is a single asset real estate debtor. Then there's, of course, a subchapter 5 case that we mentioned previously. There's Chapter 12, which is family farmer. We don't need to talk about that. Chapter 13 is your personal reorganization, or what's referred to as a wage earners plan. And then, of course, there's Chapter 15, which is a unique area of the bankruptcy code. And that's where there's recognition in the U.S. bankruptcy court for a foreign bankruptcy proceeding. So those are your various bankruptcy chapters.
Catherine, what are the Canadian comparables?
Sure. So as I said, there's 2 different statutes. One is the Bankruptcy and Insolvency Act, and one is the Companies Creditors Arrangement Act. So the Bankruptcy and Insolvency Act has been around forever. It involves either straight bankruptcy or filing what's called a notice of intention to file a proposal or a proposal under the Bankruptcy Act. And that's the section where you try to negotiate a deal with creditors. And that has two sides, a consumer proposal or what's called a Division 1 proposal. So there are two different kinds of proposals depending on the kind of debtor. There is a section dealing with recognition of foreign insolvency proceedings, and there's also a section dealing with receiverships, allowing the appointment of a receiver. So that doesn't involve bankruptcy, but it's administered by the Act. And then the second one is the Companies Creditors Arrangement Act, it's a very interesting statute because it was actually created in the Great Depression, like 1930s, and was little used forever, for decades. And it was discovered around 1990, early 1990s, and people thought this would be a great substitute for Chapter 11 bankruptcy, but it was a tiny little statute, just bare bones. And to qualify, you had to have this special kind of debt. But people found a workaround. They created instant trust indentures to qualify. And it was used for almost all of the major restructurings. And then there was an overhaul about a decade ago. It's now available for any company with more than $10 million in debt. So it's an expensive process, and reflecting on your question, it's true. A lot of large bankruptcies, they may have come out at the other end, but then they often go back in a few years later. So, and some I think have even had 2 or 3 tries. So not that many come out the other end. And frankly, even though it was intended for restructuring, it's often used for a straight liquidation. A great example was Target, because Target Canada, as most people know, was a complete flop. And instead of filing actual bankruptcy in the Bankruptcy Insolvency Act, they filed under what's called the CCAA. They never had any intention of restructuring. The business was dead. And they just used it as a means to liquidate, and they negotiated a plan. And the plan wasn't obviously to stay in business, it was to pay creditors. And creditors ended up recovering most of their debt under the plan. So surprisingly, it's probably the only one or most successful for creditors. But it's very rare to have a highly solvent parent company and just a flop going into another market. But
Sarah, we're going to talk later on about single purpose entities, et cetera, probably more in the landlord side. However, I do want to ask you this question. In the Chapter 7 liquidation, can a tenant stay in possession of premises during a Chapter 7 liquidation?
If the landlord files for bankruptcy?
No, if the tenant files for bankruptcy. We're still in the tenant perspective.
It can. The lease in Chapter 7 will be rejected automatically within 60 days if that deadline is not extended. Normally in Chapter 7, if it's a business bankruptcy as opposed to a residential tenant, Chapter 7 is almost always a straight to liquidation. There's no plan to reorganize. The business is shutting down. And so more typically in a 7, a debtor wants to stop the flow of rent. There's a trustee appointed automatically. The trustee wants to stop the flow of rent. So getting rid of leases is one of the first things that would happen. The obligation to pay, the other obligations that run to a tenant under a lease. So that leases are typically quickly rejected. But some from time to time, a trustee will say, "I need the space or some of the space to have an orderly liquidation of the business and stay and pay rent."
Richard, what's the difference between the subchapter 5 in an 11 and Chapter 13? And the reason why I asked this, you and I talked about it earlier, is that when I've represented landlords in rent collections during various recessions, there have been some tenants who filed Chapter 13 bankruptcies, and there are plans, et cetera. So if you could just give us a brief idea of what the difference is.
Well, the big difference is, first of all, with respect to a Chapter 13, you're dealing with an individual who's filing a bankruptcy and then looking to restructure, as opposed to the Subchapter 5, where that's generally going to be a business. And there's different debt limitations. So with respect to a Chapter 13, now keep in mind that these numbers, they adjust every 3 years. And I think it just readjusted April of 2019. But the debt limitation for a Chapter 13 is a little bit less than $420,000 can be owed by that Chapter 13 debtor on account of unsecured debts. And with respect to secured debts, it's a little less than $1,260,000. So those would be your debt limitations in a Chapter 13. And then if that debtor would exceed those debt limitations, then they're looking at a Chapter 11. And now, under this Subchapter 5, they could go as high as $7.5 million in total debt obligations and move forward with the streamlined reorganization.
Sarah, let's step back a second. For those who are uninitiated in bankruptcy, what is the distinction for you if you are a creditor, and whether or not you're an unsecured creditor versus a secured creditor? How does that play out in a bankruptcy case?
It's a very big difference. If you're a secured creditor, you have a lien on sometimes all the assets of the entity on bankruptcy, sometimes specific assets. So sometimes there are multiple secured creditors, and there will be a hierarchy among them. They may have liens in different assets. But if there's a lien on cash, receivables, proceeds, the debtor in bankruptcy cannot spend that money without the lien holder agreeing or a court entering an order over the lien holder's objection. Most often, deals are cut and the courts approve the deals with certain protections for the secured creditor who has a lien on cash. And then when you get to the end of the case, this is very high level points, but you get to the end of the case and distributions are made to creditors. Secured creditors are paid in full to the extent of the value of their collateral and are entitled to post-bankruptcy interest, and if their contracts provide for it, for counsel fees paid, their counsel fees paid by the debtor, all subject to certain limits, potentially in amounts, and certainly have to be reasonable. And sometimes secured creditors, in many real property related cases, will get paid earlier, such as when collateral is liquidated. So if a debtor owns multiple pieces of real property and they sell them during the course of the case, the secured creditor will often get paid, typically, as their collateral is liquidated. Unsecured creditors typically have to wait to the very end, and for unsecured creditors to get like 100 cents, that's what the bankruptcy world calls as opposed to percentages, is very rare. It takes cases like PG&E now to get a full recovery on unsecured creditors. It does happen from time to time, but most cases, unsecured creditors are thinking, am I going to get 5 cents? Am I going to get 20 cents? And it's often years out. So it's not a pleasant place to be usually.
So I'm going to tell you what my general strategy is, and when I file lawsuits to collect rent. And so I've got 3 people here who are going to tell me I'm wasting my time. But here's my strategy. It's not uncommon for us to enter into a settlement agreement after a lawsuit is filed. And we're not talking about at this moment with all of the moratoriums and stuff. But often the tenants want me to stipulate to an entry of judgment in the future, an agreement that they'll pay X amount over time, and then they'll have the judgment entered in the future if they later default. I'm not going to go into a lot of detail. I, on the other hand, prefer to have the judgment immediately entered and agree to actually withdraw the judgment, set aside the judgment, and file a dismissal if the tenant performs. And one of the reasons why I do that, and this may vary from state to state, but I'm talking about in California. One of the reasons why I do that is I want to get that judgment entered, and then I want to file a UCC lien, judgment lien. In essence, I'm looking to perfect my lien as soon as possible. And then if the tenant defaults, I usually won't do anything for at least 90 days beyond the date that I filed my UCC lien. All right, because I'm looking for, in many cases, I don't know if there are going to be any assets in a bankruptcy, but I want to put my client in the best position. And the best position would be to have them as a secured creditor. I can't get that with a writ of attachment, but I believe I can get it with a judgment so long as I file that UCC lien and perfecting the lien may vary from state to state. So this again is in California. So, okay, go ahead. Tell me how wrong I am.
I'm not going to say you're wrong, but I'd love to find out how to do that in Ontario. We don't have UCC liens.
Well, that's interesting. So, Sarah, I mean, you guys, you know me a long time, so don't be afraid to tell me that I'm wrong.
No, if you can create a judgment lien outside the preference period, yes, that is an advantage for the creditor. I think there are, in a bankruptcy case, if you get a lien, you can have a lien for a contingent claim, so that someone has a payment plan and you're getting a lien to protect against a possible default. That can be done. There's, again, some levels of reasonableness and in the magnitude, perhaps, that would be looked at. But you could do that. I think for someone to agree is a complicated issue for many creditors.
You don't know me that well, because people go bonkers when I insist upon it. There is occasion when I won't, because I might not be able to get it, or it doesn't make any difference. Or in the alternative, I asked for, we create a security agreement to secure the obligation, and then I file that.
Right, and you can guarantee for that purpose as well. So there are protections available. It's every deal is a bit bespoke.
Yeah, perfection is the important element, and that may vary from jurisdiction to jurisdiction. Unfortunately, no, I didn't do this wrong, but unfortunately, when I became general counsel of Big Bear Markets, my predecessor, I believe, had to leave because he did not perfect a security interest in an industrial bakery company, and they eventually filed bankruptcy. And there was, we actually did an appellate court case that we tried to get the court, and it was very clear. Now, I handled the litigation, but it was very clear by the time we were done, you got to perfect it. You got to, and so that's a lesson that I have never forgotten, and that's been, 40 years?
Right. And perfect the right way. Sometimes people perfect, and there are mistakes in perfection.
Oh, absolutely. Right. What type of businesses are most likely to file for bankruptcy protection? And choose the answer that best reflects your concerns. And the choices are, and here I did kind of some broad questions, and then I got a little bit more specific. Retail, office, industrial, hospitality, restaurants, and hotels, entertainment, conventions, and tourists. Let's see what else. Any business that encourages large in-person gatherings, or any business that requires close in-person contact, such as hairstylists. I can tell you that at the first earliest moment, my wife, Joanne, Sarah, you guys know, Catherine, you don't know my wife, but she is going to get her hair colored as soon as she can. And I have this thought of some woman hovering over her doing her hair. And I'm going, I don't know. So the reason why I asked that question is really, if you're dealing with any of these businesses, you should be, again, becoming knowledgeable and preparing yourself, whether you are one of those businesses, whether or not you do business with one of those businesses, or if you are a landlord to one of those businesses. I don't know if I need to ask the panelists that question. Go ahead, Sarah.
A couple of thoughts come to mind. Another industry that's real estate related that we're seeing a lot of bankruptcies, and I'm sure expect will continue, is healthcare. And when you think about hospitals and other kind of inpatient treatment centers, and there's, and it's counterintuitive. The recent health crisis is actually a large financial burden on the health industry.
Yes, it is.
Well, even before that, there were a lot of vacant hospitals. I've been working with some addiction, the addiction facility, restructuring. And so I think that's part of the real property panoply that we'll see. This is just a little anecdotal. In February, before the COVID crisis was nearly what it is now, I looked at the companies that filed Chapter 11 in the United States with over $50 million of assets. And I would say, without a precise count, just kind of a glance, that 80% of the companies that filed roughly for bankruptcy in February for Chapter 11 of that size were hospitality related, largely restaurants, and supermarkets are a close second. I didn't count precisely. I could be off a bit. I might have missed a couple and try and gather this information. But I think that's telling too, because it was when people were still going to restaurants and people were still staying in hotels.
Yeah. All right, let's move on. Landlord issues. Could you run through these, Sarah, fairly quickly? And then if anybody has any questions on some of these, we'll encourage them to get a hold of you.
Landlord issues in the event of a tenant bankruptcy. We've discussed some of them already in terms of the obligations in the bankruptcy code to pay rent, but how courts are suspending that. There's going to be interaction with companies that file for bankruptcy that have had the benefit of eviction moratorium, which means they haven't paid rent. There are protections for landlord in the bankruptcy code for things like going out of business sales at retail locations, in assumption of leases, of protecting landlords of shopping centers to maintain things like tenant nexus.
Why don't we talk a little bit about that a little bit more? One is, what is an assumption of the lease? What is the timing involved with that? And let's talk about the retail. What do you mean by preserving the tenant mix?
Well, many shopping center leases talk about, effectively to limit competition for certain brands, for certain kinds of products. So those kinds of things can be maintained. Some of it's signage, some of it's hours. So there are some protections there. On assumption, an executory contract and lease under the bankruptcy code can be assumed or rejected. One or the other has to happen if you get to a conclusion of a bankruptcy case. Focusing on Chapter 11s for the moment, assumption of a lease, and this is unique of non-residential real property leases. Again, it's different for residential leases. The debtor has 120 days, unless by motion the court reduces that, to decide whether to assume or reject. That 120-day period can be extended for 90 days with or without the landlord's consent, but if it's without the landlord's consent, with a court order. After that collective 210 days, it can only be extended further, the time within which the debtor can decide which one to do with the landlord's consent. And so assumption means you're saying, I'm committed to this lease. I'm going forward with it. Monetary defaults have to be cured, and adequate assurance of future performance has to be provided if you're going to assign the lease to a third party. An assignment can happen if, in most contracts, including real property leases, if there's a provision in the lease that says it cannot be assigned without consent, the bankruptcy code overrides that. There are exceptions in other kinds of contracts that don't usually apply to real property leases, but again, that's where you get into some of the shopping center protections available if somebody wants to, if retail goes into bankruptcy and they want to assign the lease. If the lease is rejected, which is under the bankruptcy code a breach, not termination. It's commonly thought to be termination, but technically it means it's a breach. The premises are vacated usually by the effective rejection date, if not soon after that. And then there's a cap, which is a formula and a subject of fighting in many cases on what are the damages that result from the rejection. And because the lease claims in the bankruptcy are often quite large, and in that way the bankruptcy code, depends on your point of view, but from the landlord's point of view, is typically limits the damages, which is an unsecured claim, again, except to the extent you have an LC and certain security deposits, and it plays into the claim calculations. For the moment, it's important to understand there are limits and the calculation can be.
Yeah, I think for the uninitiated, I'd like to talk about that a little bit more so that people understand what that means. In the meantime, Richard, could you talk a little bit about adequate assurances of future performance? What does that mean, and how is that determined?
Well, it's determined based upon evidence being provided to the landlord and to the court that whoever is going to be assuming the obligations under the lease, that they're able to perform all provisions of the lease. So it's not just with respect to the financial obligations, but the new tenant who's going to be assuming the obligations is going to need to perform entirely. So it's based upon, typically when I've dealt with these issues, declarations are submitted in court. Sometimes there's actually live testimony. And what you're really trying to show is the focus is primarily, I wouldn't say exclusively, but it's primarily on, is there going to be ample cash on a go-forward basis post-assumption to be able to pay all rent that's due under the terms of the lease agreement?
Good, good. That's a great explanation. Catherine, is there some similarities between U.S. law in this regard and Canadian?
Yes. In the case of a bankruptcy, for example, the trustee can assign leases and can do so over the objection of the landlord with a court order, and it's a very similar provision that you have to satisfy the court that the new tenant is going to be substantially the same or be able to perform under the lease, and in some cases satisfy the use clauses as well. So it can't be a completely different kind of tenant. So that can be a big issue. If you have one kind of retail tenant and you want to put in another kind of tenant that some landlords don't want, that can turn into a fight. So yeah, it's very similar law.
Sarah, let's talk about the damages and what all of that means. So let's assume for the moment that the tenant rejects the lease, and that becomes a breach, as you say, for bankruptcy purposes. Let's assume for the minute that there are 5 years remaining on the lease. Okay. What happens with these damages, and how are they calculated, and where do these damages go?
The damages go to become the allowed general unsecured claim of the landlord that will be treated pro rata with other unsecured creditors if and when there are distributions to unsecured creditors. And
now, the damages are the rents owing through the remainder term of the lease.
There's
are they
a
not?
cap.
Right.
There is a cap under Section 502 of the Bankruptcy Code, and I think it's, I'm pretty sure it's B6. And it is, the 15%, the lesser of, let's see, to be precise, it is the rent reserved by such lease without acceleration for the greater of 1 year or 15%, not to exceed 3 years of the remaining term of such lease following the earlier of the date the case filed or the date on which the lessor repossessed or the lessee surrendered the properties, plus any unpaid rent due under the lease without acceleration on the earlier of such dates.
Okay.
So it's complicated.
Yeah, it's complicated, but if the lease has got, if there are 5 years or 10 years remaining on the lease, the landlord is only going to become an unsecured creditor for only let's say it's 10 years remaining on the lease. The landlord is only going to become an unsecured creditor on a relatively small portion of the rents remaining, correct?
Right. And if there's unpaid rent where the property was used, that may be an administrative claim, maybe a pre-petition general unsecured claim that was pre-bankruptcy. So there could be a claim for that. But the part that isn't you actually used the premises and didn't pay for it, and this formula are gone, is not a claim. It's not paid from the bankruptcy estate.
Catherine, go right ahead.
I want to speak because if it's confusing or difficult in the U.S., it's extra confusing in Canada. So I'm just going to give an overview of the confusion because I talked about the different kinds of bankruptcy, and each one has different treatment of landlord claims. So under the Companies Creditors Arrangement Act, there's no formula and there's no set way of doing it. So, for example, in the target, they actually put landlords into a separate category of creditors, and they proposed a formula, but not the one under the Bankruptcy Act. They proposed their own formula. I represented a group of landlords. There were several other lawyers who represented other groups. So we all banded together and we fought their plan because they came up with something. We fought it successfully, and the judge set it aside and said it wasn't fair and sent them back to the drawing board, and they came up with something better than the formula. I think there's a confidentiality provision, so I can't say what it was, but it was a very generous formula. It was several years worth of rent. So, and of course, there you're dealing with a big box that's not easy to replace. Under the Bankruptcy and Insolvency Act, if you do a proposal, there is a fixed formula, which is very similar, I think, to what Sarah said. Under the Bankruptcy Act, there's a quirk in the Bankruptcy Act that says landlord-tenant rights are governed by provincial law. So it's actually different for every single province. That makes it, number one, complicated. Number two, there's huge issues as to what those provisions mean. And I actually, right now, have a case under reserve in the Court of Appeal dealing with the landlord's rights to receive or to file an unsecured proof of claim to bankruptcy. And secondly, and I missed saying this before, but there's also another case pending before the Court of Appeal dealing with a landlord's rights under a letter of credit, which was supposed to be sacrosanct, but a judge held that the landlord was not entitled to draw under the letter of credit for its losses. The appeal was scheduled to be heard, I think, next week. It's been put off because of the situation. So the law is absolutely up in the air right now on these issues. So how's that for confusing?
Well, if we can draw any conclusion from this webinar, is you better speak to an attorney, because if it's confusing to lawyers, it's going to be even more confusing to anyone who's not a lawyer.
Well, and to that point, what I was going to mention is that when you are dealing with, for example, a lease rejection claim for a landlord, there's multiple components to that claim, as Sarah was alluding to, because, for example, you have your unsecured claim. So there's an unsecured claim for any pre-petition rent that's owed. There's an unsecured claim that may be capped once the lease is rejected. Then in addition to that, sometimes there's arguments that are made that there are certain claims that the landlord has that are not part of the cap. And then in addition to that, then you have administrative expense rent that may be due as well. So the thing is that you've got to be very, very careful when it is that you would be asserting a claim, how you assert a claim, So it is very, very important to consult with an experienced bankruptcy lawyer before filing a claim.
We've got a couple of questions that I do want to get to. Before we get to, Catherine was going to be talking about a quick rundown of Canadian bankruptcy law. I don't know that you haven't already kind of explained it.
I think I jumped the gun and already did it. So
yeah.
Yes,
here's a question. If lease is coming to an end or tenant is going out of business, at the end of the lease, would you be able to, I'm not sure if this is Canadian. Oh, okay. At the end of the lease, would you be able to recover from the security deposit at the time of the moratoriums in Canada or US? So if the lease, at the end of the lease, I'm assuming that the question is if the lease is coming to an end about now, would you be able to recover the security deposit at the time of the moratorium in Canada or US? I have the answer to that. I'm assuming it depends upon the jurisdiction, but if it was in California, you can't draw upon the you can't draw upon the security deposit. But now that I think about it, it's like the purpose of drawing on the security deposit is that they don't want people to draw upon the security deposit and ask for a replacement. If the lease has been terminated, what difference does it make? Anybody got any thoughts on that?
Well, I'm just going to say I'm just in the process of settling a case involving the issue on the right to draw on a security deposit during bankruptcy. So we've already settled it. We haven't papered it yet, but I mean it's a live issue. It can be a live issue. I don't think any of our COVID legislation would prevent a landlord from drawing on a security deposit, however, but California may be different. So.
You may be able to do it if the lease has already been terminated. So I'm not really sure.
I think there's a difference between saying you can't draw and saying you can't ask for it to being replenished. That's outside of bankruptcy as well as inside of bankruptcy. And I think we're going to see some of these moratoriums get revised. Some will get extended. Some may get more narrow as the landlords say, hey, we have our own bills to pay too.
Mm-hmm. Yep. No, absolutely. Okay, so let's move on. Let's look at the landlord's perspective. In the U.S., Richard, why don't you start? Actually, I have a note here that says Sarah and Catherine. Sarah, you want to do that? Talk about the automatic stay, relief from stay, state court or province actions for rent or eviction, what generally happens?
And again, we're talking now about the debtor is a tenant still, right? Not the debtor is the landlord.
Yeah, I don't know if we're going to have enough time to get to the landlord side. We may have to schedule another one. The
automatic stay in the U.S. comes into effect immediately upon the commencement of a bankruptcy case. That includes an involuntary bankruptcy case in many ways. So once that happens, all litigation against the debtor cannot proceed without getting what's called relief from the automatic stay through a bankruptcy court order. So that includes evictions, it includes sending default notices, termination notices, any efforts to collect other than through the bankruptcy court procedures. Relief from stay is the mechanism a landlord would use to try to say, I'm special, I'm unique, the burden is particularly hard on me, I want to be able to terminate my lease now. Or another thing a landlord can do is ask the court to compel the debtor to immediately decide whether it wants to assume or reject the lease. If a lease by its terms expires during bankruptcy, it just expires. However, if there's some kind of evergreen renewal clause, bankruptcy, that keeps going. You can't say, you can't send your notice 60 days, you can tell the tenant to move out. Bankruptcy stops that. So from a landlord's point of view, those are important things to think about if your tenant's on the brink of bankruptcy. You may think, I'm working with them, it's a hard time, and it is. And you want to have a long-term tenant, important, very important consideration. But you may also, particularly if you have a long lead time to terminate an automatic renewal, for example, you may choose to send the notice and literally blame the lawyers, and continue your good, strong business relationships between the tenant and the landlord, saying, my lawyer told me I should do this. I still want to work it out. And in fact, you may well work it out. But you may be kicking yourself if you didn't send the notice and they filed for bankruptcy 62 days after you could have sent a 60-day notice. And now you're stuck.
Yeah, I'd like to add, because I handle this in state court. A lot of times the stay order, we're ready to go to trial, and the day before we go to trial, all of a sudden we get a notice of the automatic stay. When that happens, and I'm representing the landlord, I have to notify the court if the tenant hasn't, and the judge will just stop and then schedule something for 2 months in advance to revisit the case, etc. Now, relief from the stay typically occurs when, after the filing of the bankruptcy petition, the tenant still isn't paying rent that is due, that what we call administrative rent. All right. Is that correct, guys? I call it administrative rent, but basically from the time that they file the bankruptcy petition, they have to pay their rent, and, we'll file relief from stay if they haven't. However, in these circumstances, according to what you're telling me in the bankruptcy court rules, the temporary change in the rules is if the tenant doesn't have to pay their rent, for a period of time, like, what was it, 60 days after the filing of the petition, you're not going to file a motion for relief from stay if the tenant isn't paying their rent. Sarah?
That's right. And there would be no point if the court has ruled that way, because the judge will say, I already told them they didn't have to pay rent, so clearly I'm not letting you terminate your lease because they haven't paid your rent.
Catherine?
I was just going to say, I don't think I've seen that yet here, where the judges have made such an order, but I think it's quite possible they will make such an order during COVID, notwithstanding that the Bankruptcy Insolvency Act and the CCAA both say that the tenant is required to pay current for the use of leased premises. But I can see these are special circumstances, and judges sort of feel they can do what they like to relieve against really harsh circumstances. So
I don't know if they have this situation. Richard, why don't you talk about repeated and consecutive bankruptcies and what landlords can do under those circumstances?
Well, sometimes what a court will entertain will be what we call in rem relief, where, to the extent that there are serial bankruptcies that have been filed and the property is part of those various bankruptcies, then generally what happens is it's the debtor that has some ownership or possessory interest in the property that is protected by the automatic stay. So what a creditor would do, a landlord may do, is file a motion for relief from stay requesting in rem relief, so that there's relief from stay granted, and it's not just as to the debtor's ownership interest, it's as to the underlying property. And as a result, that property should not be subject to any automatic stay or any subsequent bankruptcy down the road. That's the kind of relief that is requested. It's extraordinary to ask for it, but then again, also based upon the facts and circumstances, I've seen it granted routinely, especially when there's been abuse.
Yeah.
So.
All right, let's get back to our final poll question. And that should be, how long do you think it will be before the economy gets back to where it was in January 2020? And I felt that this was an important question because I don't think that we're going to see a lot of bankruptcies. There'll be an increase in bankruptcies over the next 2 months, but I suspect that we're going to see the uptick in bankruptcies, a significant uptick, 6 months from now. So I think the important thing is to determine how long this is going to be. So I am now going to publish the poll, and why don't you, the answers are less than 3 months, less than 6 months, 6 to 12 months, 12 to 18 months, and 18 months or more. This is a little scary. We've got a bunch of cynics on here. I suppose anybody who's here to learn about bankruptcy has got to be a bit of a cynic. So we have 18 months or more is 60% of the people. 12 to 18 months is 22%, and 6 to 12 months is 9%. Nobody thinks that it'll be less than 3 months, and nobody thinks that it's going to be less than 6 months. And I think the real kicker is not when do we expect to see improvement, but when do we see things back to January 2020, which I used as the guidepost for where things were prior to that. Okay, let's talk quickly about landlord bankruptcy. U.S. law, tenant's perspective on a landlord bankruptcy. Who are we going to? Somebody raised their hand. We never decided who was going to lead with this. I could just choose someone because anybody could do it. How about Richard?
So what is it exactly that we want to be talking about?
Well, we're talking about a landlord bankruptcy. Why don't we just start with Sarah? And I'm going to start with Sarah because we were talking about a single purpose entity, which we have a lot of landlords who own properties as single purpose entities. So why don't we talk about U.S. law and the tenant's perspective if the landlord files bankruptcy?
Well, from the tenant's perspective, if the landlord wants to reject a lease, the tenant could opt to stay in the premises for the duration of the lease, including extensions. The tenant would have to comply with the rent obligations. There are some limits on whether the landlord and what the landlord has to do, because the landlord may not stay the owner of the building. The building may be sold. There are issues on what happens if there are subordination agreements, attornment agreements, and what would happen in a sale can get complicated and vary between jurisdictions. But generally speaking, from the tenant's point of view, in a landlord's bankruptcy, they may have creditor claims if the landlord did not fulfill its obligations. But the important thing, unlike most kinds of results of rejection, the tenant can stay in the premises if it elects to do so.
And that's important. But they could. Now, what if they don't want to stay and the landlord hasn't rejected it? They still have to stay if the landlord hasn't rejected the lease?
Well, they can, they don't have to stay. They can't be forced to stay. The question is whether they can be forced to pay rent.
Well, that's what I meant. There's a difference between the obligation and the reality of whether or not they stay. Catherine, why don't you give us an idea from the Canadian law?
Sure. I was just going to say that the bankruptcy of the landlord really shouldn't make any difference to the tenant. It doesn't affect the lease between the landlord and the tenant. The trustee in bankruptcy would just step into the shoes of the landlord. Now, if it's, say it's a non-arm's length, very low rent lease, subordinate to mortgagees, the trustee receiver may be able to remove the tenant, but in the ordinary course, the trustee is bound by the lease terms. So it shouldn't affect the tenant.
I'd like to thank each of you. Why don't we start with Catherine? Catherine, how do people get a hold of you?
Well, I'm at Min & Gross LLP in Toronto, and my email address, phone number are on our website. It's pretty easy. My phone's redirecting to my home right now. Probably a lot of us.
Okay. And Richard, how do people get a hold of you?
So my firm is Winthrop Galibo Hollander, and probably the best way to get a hold of me right now would be to call me on my office line, As Catherine was alluding to, I actually took my office phone home, plugged it into my router, and I'm making and receiving calls as if I'm sitting in my office. So I could give out that number.
Sure,
Or
if you want to, why not?
So it's area code 949-720-4135. That's a direct dial. Alternatively, of course, people can go onto the website, which is wghlawyers.com, and get all my contact information that way.
Great. And Sarah?
The technology is amazing for all of us.
Yeah.
My direct line's 310-788-3218. Email is schenetz@perkinscoie, that's COIE.com. And you can also find me through the website, LinkedIn, and probably a Google search.
Yeah, Sarah spells her last name CHENETZ. Richard spells his last name.
Don't mess this up, Howard.
Yeah, GOLUBOW, and Catherine's last name is Francis, FRANCIS. And whatever you do, don't misspell my name. Everybody misspells my name. It's KLINE. It's not KLEIN. All right, so I'm one of those. It's like Kevin, and you can get a hold of me by calling me at 949-954-6699, or send an email to me at howard@hfklaw.com. And so, with that being said, any final comments, Richard?
No, I just really appreciate the opportunity to speak with you and my fellow panelists, and hopefully this is very helpful to all the attendees.
Should I mention the dog, by the way?
It's not mine. I don't know whose it is.
It's
Not
my
mine.
dog. I think it's my dog. I'm not sure which of the two. We have a corgi and then we have a mutt. I think it's the mutt.
It might be the
She's
mutt.
11 pounds and she doesn't realize just exactly how small she is.
Oh, okay. Sarah, any closing comments?
Yeah, interesting to hear everybody's perspective. Thanks everybody in the audience and the panelists for the time, and be well.
Great. And Catherine, any final comments?
I'm just scared when I see this. Actually, 64% is up to 18 months or more before we're back to normal. So now I'm more terrified than ever.
Yeah,
normal. It's a scary thing.
And it will be a new normal. Thank you, everyone. I'd like to thank the audience. For those of you who didn't make it, you'll see this later on. It'll be a recording. All, thank you very much. Stay healthy. It's a wrap.